Employee Discipline by Marlana Bays. Employee discipline is an important union management issue. It is the most frequently heard injustice in arbitration. It is propositioned consistently by arbitrators who usually rely on established principles to make their calculations. Historical overview of employer disciplinary policies. During the 18th and 19th centuries, the employer exercised unrestricted discretion in directing the workforce. All may dismiss their employees at will, be they many or few, for good cause, for no cause, or even for cause morally wrong, without being thereby guilty of legal wrong. Tennessee Judge in 1884. This quote laid the foundation for the 130-year-old employment at will doctrine. By the 1930s, management's total option to discipline employees was challenged on practical and legal grounds. The Wagner Act of 1935. It helped shape management's disciplinary policies. Its primary feature was the prohibition of discriminatory discipline of employees because of their union activities or membership. The National Labor Relations Board was created for enforcement purposes. Management defended disciplinary actions against charges filed within the agency. The NLRB affected organizational discipline procedures indirectly when it ruled that discipline and grievance procedures were mandatory issues for collective bargaining. 3 broad powers on discipline. Number 1, to determine what constitutes just cause for discipline. Number 2, to establish standards of proof and evidence. Number 3, to review and modify or eliminate the penalty imposed by management when warranted. Ways discipline can improve efficiency by accomplishing the following purposes. Set an example of appropriate behavior. Transmit rules of the organization. Promote efficient production. Maintain respect for the supervisor, and correct an employee's behavior. Employment at will doctrine and wrongful discharge consideration for non-union employees. More than 88% of the United States workforce, 116 million workers, are not afforded the protection of a union contract or collectively bargained grievance arbitration procedure. Under the public policy exception to the employee at will doctrine, an employee is wrongfully discharged if the discharge is inconsistent with an explicit, well-established public policy of the state. The implied contract exception to the employment at will doctrine occurs when an employer and employee form an implied contract, even though there is no express written instrument regarding the employment relationship. The covenant of good faith and fair dealing exception to the employment at will doctrine means that employer personnel decisions are subject to the just cause standard, prohibiting terminations made in bad faith or motivated by malice. 7 tests. Helps decide whether or not just cause exists for upholding or overturning a discharge by an employer. Not all are equally important in all situations and are not relevant in every case. When using the 7 tests, arbitrators typically 1. Review the facts on which the disciplinary action was based and how the employer determined these facts, and 2. Assessment of whether the level of discipline was justified. Arbitrators include 3 major components in defining just cause. 1 being industrial equal protection. 2. Individualized treatment, and 3. Industrial due process. Degree of proof in disciplinary cases. Arbitrators use 3 levels of proof. 1. The most often used level of proof is preponderance of evidence. Testimony and evidence must be adequate to overcome opposing presumptions and evidence. It is usually used in disputes over interpretation and application of contract language which do not deal with discipline, overtime assignments, promotions, etc. Number 2, clear and convincing evidence is shown where the truth of the facts asserted is highly probable. This level of proof is used mostly most commonly in disciplinary matters that are non-criminal in nature, such as excessive absences, unacceptable performance, etc. Number 3, beyond a reasonable doubt represents a higher degree of proof. Some arbitrators use in criminal nature, such as selling illegal drugs on company property or stealing. It can more adversely affect the grievance chances of finding employment or even lead to incarceration. Progressive discipline refers to increasingly severe penalties corresponding to repeated identical offenses committed by an employee. An oral warning or reprimand represents an informal effort to correct and improve the employee's work performance. A written warning, the next step in progressive discipline, is a more serious matter because it summarizes the previous oral warnings to correct the employee's behaviors and is entered in the employee's work record file. A suspension is a disciplinary layoff without pay given by management to impress on the employee the seriousness of the offense. A last chance agreement gives the employee another chance to improve his or her performance or conduct in order to keep his or her job. Due process. Due process has both substantive and procedural aspects. Substantive due process focuses on the purpose or rationale of the work rules to ensure that an employee has not been arbitrarily disciplined or discharged. Procedural aspects of due process are usually covered in labor agreements and include the following. The existence of a procedure that has rules is known, is predictable, and is not arbitrary. Rules are applicable and administered equitably to all employees. It includes the right to be represented, the right to present evidence and rebut charges, the right to know the charges, and the right to relevant information concerning the charges. The right to a fair and impartial fact-finding process and hearing, to be free from retaliation, and the right to as much privacy and confidentiality as is practicable. Other due process requirements which may be written in the labor agreement include: the discipline process will follow certain time limits specified in the labor agreement. The employee will be entitled to union representation if requested prior to discipline being administered and will be given an opportunity to respond or defend himself or herself. The employee will be notified of the specific offense in writing. Written notice has caused some problems for management and is a major reason for the involvement of labor relations representatives in the discipline process. Double jeopardy is punishing an employee twice for the same offense. This doctrine most commonly comes into play when management assigns an employee a more severe penalty after the one has been originally given. Due process and the Weingarten decision. The Weingarten decision pertained to an employee who was believed to have paid only a fraction of the price for food she took out of the store. During the interview with management representatives, she repeatedly asked for a union representative to be present but was denied. Although she was not disciplined, she reported to her union representatives that she had requested union representation, and it was denied. The union filed an unfair labor practice violating Section 8 of the National Labor Relations Act by denying the employee union representation. The NLRB ruled that union representation must be given to the employee at an employee's request when the employee reasonably believes an investigation could result in disciplinary action. Unions' communication with members on Weingarten rights. During the years in which Weingarten rights were extended to non-union employees, several interesting issues were raised. 1. There is a question of whether the rules developed by decisions of the NLRB since the Supreme Court's 1975 Weingarten decision will be applied to non-union settings. 2. There is a question of who will serve as a witness. 3. There is a question of the role of the witness in a non-union setting. 4. There is a question concerning the employer's actions when an employee asserts Weingarten rights and requests a coworker as a witness. 5. A fifth dilemma for the employer is the pay for the coworker representative. Summary. Employee discipline represents the most significant day-to-day issue in administering the labor agreement. For both union and management, administration of discipline is a key factor related to control and production. The supervisor and the affected employee are even more directly and personally affected. Discipline in unionized settings must be for just cause, a concept consisting of several dimensions. Management has the burden of proof to establish that an employee committed an infraction. An employee has the legal right to have a union representative present during an investigatory interview if the employee reasonably believes that the investigation could result in disciplinary action. My resources were the book, The Labor Relations Process, 11th edition by Holly Ross and Walters.